Thank you. You may be seated.
The Supreme Court is now in session.
The last case today is the State of Alaska Division of Elections. Excuse me, I don't have the parties. Kevin Myer versus Alaskans for Better Elections. Both counsel are present. Ms. Fox, you may begin the argument.
May it please the court, my name is Laura Fox and I represent the Lieutenant Governor in the Division of Elections. Alaska has a single subject rule that's supposed to protect voters' ability to effectively exercise their right to vote by requiring that different proposals be voted on separately. Here, there can be no real dispute that the Better Elections Initiative contains 3 different legal reforms and that what they have in common is just that they all have to do with elections. The question is whether that's enough to force voters into a totally unnecessary Hobson's choice to take or leave these 3 reforms together as a single package. The state's answer is no. Voters deserve the chance to express their views on these different proposals separately. And separating them would be easy, and the benefit to voters would outweigh the inconvenience to sponsors. And so if the court's precedent requires forcing voters into this unnecessary choice, the court should overrule that precedent. Otherwise, the single subject rule is not going to actually accomplish its purposes. Its purposes are about protecting voters. And it's precisely because the initiative power is important that the court should care about the rule actually accomplishing its purposes to protect the voters. And so, first I'll address Croft versus Parnell, which is the court's most recent precedent on some single subject rule, and then I'll address the arguments about overruling older precedent.
So before you do that, in Croft, which was the first case where we actually rejected the argument, we didn't have to overrule precedent. We just distinguished other precedent from the matter that was before Croft. Can we do the same thing here?
I think the court could in some ways. So, well, the state's argument about overruling precedent is basically targeted at the court's statement in prior cases that the same single subject standard applies to initiatives as applies to other legislation. I think the court could also distinguish this case. What this case has in common with Croft that doesn't really have in common with other cases is also that it's sort of it's a pre-election challenge. We're talking about a different sort of posture than in a lot of the other cases. So we're not talking about some law that's been on the books for a while and somebody's coming along and saying, well, back when that law was enacted, it was part of a bill that included multiple subjects, and now I don't want to have to comply with that law after the fact. Some of those other cases were like that. This is a lot of the other cases were like that. Whereas here we're talking about,
in fact, right? Like most of the precedent involved some not quite stated. It's already been done. We don't want to undo it.
Right. And so it makes sense in that kind of perspective to sort of put a kind of a gloss on the single subject rule where, okay, maybe that's a closed case or maybe we're not sure, but, it has to be, if we're going to be invalidating some law after the fact, down the road or, once it's already been voted on, etc., we want it to be a really obvious violation. Whereas here, the problem can still be fixed before this goes on the ballot. We can still fix this. Voters haven't voted on it. It's still at a point when it would be easy to prevent the single subject problem from really reaching that later stage. So that is a way to distinguish this case from the other cases. And really, Croft did sort of reinvigorate the single subject rule by talking about the purposes that it's supposed to serve in the initiative context, why we have the rule, why it's important, how it protects voters. And so if we think about those purposes that the court discussed in Croft, they're really just not served at all by a rule that allows very broad blanket subjects like elections. And so it's language and reasoning in the Croft decision that leads to the conclusion that this initiative violates the rule. So, according to the language of Croft, when we have different proposals, they need to be voted on separately in order for voters to be able to, quote, effectively exercise their right to vote. And according to the language of Croft, bundling together unrelated proposals deprives voters of the, quote, opportunity to express their approval or disapproval of each distinct proposal.
What would you think about allowing the replacing of the current party primary system with an open, nonpartisan primary and establishing a ranked choice voting in the general election to fly together, and then peel off the adopting the new disclosure and disclaimer requirements.
Well, the two that Your Honor proposed putting together are unrelated proposals too.
They're more related than the two of them to the third.
I'm not even sure they're more related than the two of them to the third, because still, I mean, one of them is about how the primary process is going to work, whether we're going to have a primary, whether political parties are going to be involved, like how candidates are going to get nominated. And then the other one is about the general election and how we're going to be doing voting in the general election. I mean, they also...
They both have to do with voting.
Well, one of them, I suppose one of them has to do with voting, ranked choice voting, the manner of voting. The other one has to do with
Selection.
how we're going to be nominating candidates.
Right.
And so that's not really about voting exactly. I mean, and again, either of them can be enacted completely independently of the other. And neither of them, depends on the other to function. And they're also not sort of implementation details of some broader program, some broader policy. They're two separate policies, both of which the sponsors think are good ideas. But they're not, they are separate proposals that voters, and they're both major proposals also, that voters should be able to vote on separately.
If the legislature had packaged these three things together in a bill, would it violate the single subject rule under our precedent?
No, I think that elections, just like the other broad subjects that the courts allowed under its single subject precedent, elections would be like land or criminal law or some of these other cases. I think under that precedent, that would fly. So.
So if we disagree with you about changing our precedent from, was it Ute Air, or whichever one is the one where, or maybe it was an earlier case where we said that we would treat them the same, whether it was legislation or whether it was something submitted to the voters, we said that we would treat them the same. And you want us to reverse that. If we don't, then what is your position on the single subject rule in terms of overruling earlier precedent and tightening it up, which means it would affect the legislature as well as initiative?
Well, I mean, I think our argument is that the considerations are all different in the initiative versus the legislative context. So
I understand your argument. I was giving you a hypothetical that we don't agree with you on that. I understand the argument. If we don't agree with that, and we say that the rule has to be the same for both, then where are you with regard to saying that we should reverse our precedent on how broadly we look at the single subject rule?
I don't think, I mean, the court could tighten the single subject rule for the legislature also. I think that would cause problems that tightening it for the initiative wouldn't cause because of the ways that those considerations play out differently. I don't know that we would ask the court to adopt the single subject rule we're asking for initiatives for the legislature, because I think that would create some different problems because of the ways that I think there's a balance between efficiency on the one hand. So Croft talks about this balance that we want to have. We don't have a too strict single subject rule because then we're going to have some efficiency concerns. And so there's two sides of that balance. One is advancing the purposes of the single subject rule. The other side of the balance is these efficiency concerns. And between the two contexts, legislative versus initiative, both sides of those ballots come out differently. So on the purposes side, all of those purposes, which I haven't discussed yet, but the court talked about across the purposes of the single subject rule, the dangers that it's meant to guard against are heightened in the initiative context. So on that one side of the scale, we have more weight, and then on the efficiency side of the scale, the reasons, the needs for efficiency, the reasons to defer to the legislative process are different on the other side. So the balance just comes out differently in two contexts. And I think if you were to say, well, no, we're definitely adopting the same rule in both contexts, I think, I guess that would be sort of sacrificing the ability to protect the voters in the way that the single subject rule is meant to do. But maybe that would be necessary for the purposes of legislative efficiency if we're going to have the same rule across the board. So
there's a third consideration also that Justice Moore in his dissent in the Ute-Alaska Air case talked about. In the legislature, you have the process and procedure whereby you get various readings on a bill, you can amend bills and things like that, whereas in the initiative context, you have none of that, and it's just an all or nothing, up or down process.
Right, and I think that's on the that's sort of why, that's one of the main reasons why the risks that the single subject rule is meant to protect against are heightened in the initiative context. So just to use what Croft said about the purposes behind the rule. So it says, separating out the distinct proposals, 1, allows voters to express their will through their votes more precisely, 2, prevents the adoption of policies through stealth or fraud, and 3, prevents the passage of measures lacking popular support by means of log rolling. So all of those things are more of a concern in the initiative context than in the legislative context for just the reasons Your Honor was citing. That in the legislative process we have this mandated public deliberative process where, we've got 2 houses of the legislature. A bill goes through this lengthy process. There's debating, there's amending, there's, people researching, people testifying, people coming to the legislature. There's just a lot of process. In the initiative context.
At the end of the day, now, there's one bill, and you either vote for it or you get a vote against it, no matter what's in the bill, right?
Right, but there was a lot
Because there was a lot of process doesn't mean that the same problems aren't there, is it?
Well, but on the one hand, you have, in the initiative context, there's one bill. The initiative sponsors came up with it however they came up with it. There's no mandated process that went into that at all. So they come up with their one bill however they want, and it just goes on the ballot for voters, including voters who are looking at it for the first time on the ballot and having to decide.
Is what our Constitution contemplates by giving the people the power of the initiative? They go do exactly what they did, and they want to put together a bill, or I'll call it a bill, but they want to put together this initiative, and they submit it to the voters. That's what the Constitution says.
But the single subject rule, again, it's supposed to serve these purposes, and if an interpretation of the single subject rule that allows these sort of broad initiative bills, combining multifaceted different proposals under these broad headings, a single subject rule that allows that kind of initiative doesn't actually further any of these purposes that the court talked about in Croft. And it's different in the legislative context because there's these other safeguards in play, other methods of review. There's even, on top of that, the governor's veto power that's applicable to normal legislation and not to initiative. So there's all this review happening versus, on the other hand, we have whatever the sponsors put in the voters, and the voter gets into the ballot box, looks at it, and has to make a decision. And so if we want the single subject rule to actually be advancing the purposes that the court talked about in Croft, it has to do something beyond just say, well, at least the voter's going to know that all these things have to do with elections. If you have 10 different proposals that all have to do with elections, changing all manner of things about elections, the voter gets into the ballot box and looks at that and has to make an up or down vote, as contrasted with the legislative process that would happen in considering that bill.
So the hybrid kind of case where the legislature passes a bill and then it's subject to voter approval, like with bonds. And we had the one case where it was the Fairbanks flood control project, and then it was a small harbor someplace else that was combined by the legislature into one bill. It was a challenge on the single subject, and it was going to the voters. Was that case wrongly decided then? And every separate bond proposal needs to be set out for the voters so that the voters can have their opportunity to weigh in on each and every one of these ideas?
Well, I think so. It's just bonds that have that kind of separate process. And I think, we proposed that under the standard, that another thing the court can consider is the sort of individual significance of the reform. So a package of different bond proposals are not going to be a whole bunch of major revisions to the law, right? They're all going to be bond proposals of different kinds. The voter understands this is a package of bond proposals. I can go through it. I can look at them. There are some of those concerns, but it's not the same kind of concern as taking sort of 3 different fundamental changes to how we're running elections and putting those together. So like a package of minor tweaks to existing law raises different concerns, lesser concerns maybe than combining in one package 3 different major reform proposals that are fundamentally changing the law. So I think packages of bond proposals maybe would be permissible under that part of the state's proposed standard. So that's kind of different consideration than what we have here. So,
Counsel, you make excellent policy arguments for why the rules should be different in legislation rather than the initiative. But I still feel very confined by the language of the Constitution and the language of the statutes. Is there anything in the constitutional history or the legislative history that indicates that either the founders or the legislature intended these words to have different meanings in these different contexts?
well, the court does apply constitutional provisions in light of the policies that they're supposed to serve, and so the purposes that they're supposed to serve. And here, the constitutional language doesn't even necessarily make clear that the single subject rule applies to initiatives. Now, it does apply to initiatives, but everything about the initiative process is different than the legislative process. So everything about the way that the people pass a law by initiative is different than the process by which the legislature passes a bill. And so we're applying this single subject rule to these 2 completely different processes, and as we were discussing, the policy considerations are different in the 2 contexts. And so if the court wants to be applying the rule in a way that furthers the purposes that are behind the rule and that balances that balance that Croft talked about between efficiency and advancing the rule's purposes, then it's going to come out differently in the 2 contexts.
If we're not bound by the Constitution, then wouldn't this be an excellent place for the legislature to step in and clarify the statutes that seem to use the same language for both types of bills?
Well, the legislature did enact a statute that says that yes, the single subject rule applies to initiatives, and there's some suggestion in the legislative history that they wanted to make sure that yes, initiatives should be combined to a single subject. There was some concern that a particular initiative wasn't. So if the court wanted to, rely on that statute, perhaps it could, because this is not a restriction on what the people can do by initiative. They can still make the same legal changes as the legislature, except where expressly excluded. They just, as they already do have to do it by a different process. And because of these concerns that we've been discussing, it makes sense to require separate proposals to be in separate initiatives so that voters can vote on them separately. And so, the root of so in Ute Air, I think it's just discussed in the briefing, Ute Air thought that Article 12, Section 11 mandated the same rule in both contexts. I think it's explained in the briefing why that wasn't correct. It's originally erroneous by our argument, because that constitutional provision is just talking about what kinds of legal changes the people can make by initiative, not the process they use, because obviously they use a different process. And so all of these policy considerations that we've been discussing are the reasons why that more good than harm would result from overruling that holding, and also why it's originally erroneous, because it's sort of incorrect that the policy considerations are the same in both contexts. And so a lax single subject rule in the initiative context prioritizes the convenience of sponsors over the protection of the voters, who are actually the people who are the lawmakers here. And we're not saying that these kinds of initiatives can't be put on the ballot. It's just that there's no reason, really, there's no reason that they have to be combined together and bundled together in the same initiative, other than the convenience of sponsors. And if there is, in some case, it's particularly difficult to split up the different ideas that sponsors have, then probably those proposals are interrelated under the state's proposed standard. So if there is some reason beyond just convenience that these proposals need to go together, then that would pass under the state standard. And so that just because the sponsors have multiple ideas that they think are good at the same time doesn't mean that they need to go before the voters, in one initiative as opposed to three. And the sponsors' efforts can be combined, to trying to advance those initiatives at the same time, unless there's, whether or not they're one initiative. So, the minor inconvenience to sponsors is worth the benefit to voters of being able to more precisely express their will, to know what they're voting on, to be making a clear statement, and not to have to vote for something they don't want in order to get something they do want, or vice versa. So, the court should apply the single subject rule in a way that actually accomplishes the purposes that it's geared toward. And so here, the court should allow the voters to express their views separately on these three major proposals rather than forcing voters into an unnecessary all-or-nothing choice on them. And the state, therefore, respectfully requests that the court reverse the Superior Court's decision and uphold the Lieutenant Governor's refusal to certify the initiative. And I'll save the remainder of my time unless the court has more questions right now.
Thank you, counsel. Mr. Kent.
Thank you. May it please the court, Scott Kendall here on behalf of Alaskans for Better Elections. And I do want to say I appreciate the speed with which the Supreme Court has dealt with this issue and approached it, because it's very important. I kind of want to start out by pointing out the state's primary argument here, and I think Ms. Fox really restated it, is their ask is that this court overturn 50 years of consistent precedent and 50 years of consistent case law and two long-standing precedents, and impose them retroactively on a ballot measure that's been drafted in reliance on those.
There is a little bit of a difference here, though, because in some of these cases in the past 50 years, the court, or at least individual members, have bemoaned how the court had originally interpreted this single subject provision. There's language, for example, that says if we were writing on a clean slate today, we might do something entirely different. So it's not like this concern has not been lingering.
Certainly. When I refer to consistent case law, I believe consistent outcomes. Every one of the decisions was decided in a way that interprets the current version of the single subject rule, again restated in the Croft case most recently. But the two parts, what they need is, first of all, they need to decouple the single subject rule for legislative enactments from ballot measures. And I think Ms. Fox maybe even perhaps admitted that it's fatal to the state's case, that if you don't decouple those two, we can't possibly apply the new single subject rule we've created to the legislature, because that's going to create myriad problems. That's sort of a concession made for the first time. But the second part is they're going to craft this brand new single subject rule, something out of whole cloth, a little from Massachusetts, a little from wherever, maybe Washington State, and impose that on these sponsors who drafted an initiative, again, on, if not absolutely unanimous in every case, the very consistent application of the single subject rule. It's some sort of two-part relatedness test where, okay, if you're addressing something important, we're going to ratchet up how related that has to be. A subjective test that no one's ever applied in Alaska, that the Lieutenant Governor apparently, as a matter of first impression, is now going to apply in the future. The state continues to say they're protecting voters from having this Hobson's choice, but this new rule, if accepted, not only would make them unable to vote on this proposal, it would fundamentally alter and diminish the process by which they legislate by initiative in the future.
I don't know if I agree with that. Under the state's theory, the voters theoretically are going to get an opportunity to vote on all three of the proposals separately. They still get to vote. They get to express their views on whether any one or all of them should pass.
The record on this, it's a little muddled, but it's perhaps clear in the Supreme Court briefing that the state's original position was break them apart, start over. Break them apart, start over. Unclear if that's two pieces, three pieces, or what. There is some indication now the state's conceding that you could break them apart and still have them on the ballot, which would, although this court has in the past deleted portions of ballot measures that are unconstitutional, I'm unaware of any prior case where they've made one enactment into several. And again, this would have an unbelievably deleterious effect on the people's ability to enact these proposals. For example, recently passed marijuana ballot measure. Main purpose of that was to allow retail sales of marijuana. It included a new enforcement board. It included a regime for testing. It included a regime for growing. It included retail sales licenses. It included a tax.
But those are all components of what I think Ms. Fox referred to as a common program or common goal.
Right, and the common goal here would be
But it doesn't
creating
look the same, right? I mean, as Justice Stowers said earlier, you could do away with the primary system as one part suggests, without ever doing anything to the general election, or without ever doing anything to disclosure laws.
And you could certainly have retail sales of marijuana without taxing those sales. There's no reason why. The retail sales would work the same, and yet the people took a comprehensive look at this and said, let's strike a balance. Let's tax for purposes of a little more state revenue, probably also for purposes of making the argument that we're going to mitigate any negative effects from legalizing marijuana.
Or to actually give practical effect to this sea change in the law.
Correct.
Right? You can't just suddenly say, starting tomorrow, this is legal, hope it works out.
Right. And perhaps here it's a kind of a good point to kind of step back and say, and review, this is what 19 ACB does. So the parties agree there are sort of three components, so to speak. Dark money disclosures, so that entities and donors can't funnel money through an entity that doesn't otherwise have to report its donors, and then they show up in support of campaigns. The argument being, I could talk to my uncle, he donates $5 million in support of my campaign, but it went through the RGA, or it went through the American Chamber of Commerce, or it went through Planned Parenthood. And the public in Alaska would never have any idea where that money came from or why. Voters are more empowered when they have accurate and timely info regarding who's influencing their vote. Now this becomes more important, and this ties into the interrelatedness, is in a world where we have an open primary and the top 4 vote getters move on to the general election, there's no longer an official Democratic or Republican candidate. There might be 2 Republicans, or 2 people who call themselves Republicans, 2 Democrats, 3 of a kind. No party officials at all. In the past, many people have gone to the ballot and they've relied on the party brand and they vote that ticket. In this world where the voters are more empowered and now they have the power they can vote for a Democratic House candidate, at the same time vote for a Republican for U.S. Senate, but at the same time that information that they get will be crucial to making those decisions in an informed way. Removing an increasing problem of dark money, where we've had elections where in excess of $50 million have been spent on a single race, which still nationwide is the all-time record for dollars spent per vote. In a world where that's the status quo, we think this is part and parcel of a reformed election system.
I understand your arguments and the policies behind each one of these 3 provisions, but it seems to me that they could be targeting different demographics or different populations, and there may be a number of people who would agree with your dark money argument, but they feel really strongly, about the 2-party primary system that we have, and so if they were split, they may very well enact one of the provisions, but if they're grouped together, they may end up torpedoing the provision that they would like to approve because they disagree with one of the others. Doesn't it make more sense to divide them up because they really are addressing discrete problems, even though you could say in an umbrella sense they all have to do with election reforms?
So there's a world in which you could make a policy argument that some would prefer to take all of these issues a la carte, and I think it's fair to make that policy argument, but we can't get there from where we are unless this ballot measure clearly and obviously violates a single subject rule, because without a constitutional violation, this package de facto should go forward. And again, I think, your argument could relate to the marijuana initiative. I'm sure there's a lot of people who would love to legalize retail sales of marijuana who don't want to tax driving the price up. I'm sure in the sense of the cruise ship head tax, I'm sure there's a ton of people who support putting a head tax on cruise ship passengers, but may not necessarily want that money spent on the waterfront in Juneau or spent for the Ocean Rangers program. They might just want that going into the general fund. But that's the give and take that's there. And really, unless we...
The Alaska Municipal League and Alaska Conference of Mayors believe in strengthening local government for a stronger...
who would love to legalize retail sales of marijuana, who don't want to tax driving the price up. I'm sure in the sense of the cruise ship head tax, I'm sure there's a ton of people who support taxing, putting a head tax on cruise ship passengers, but may not necessarily want that money spent on the waterfront in Juneau or spent for the Ocean Rangers program. They might just want that going into the general fund. But that's the give and take that's there. And really, unless we come to the point where these matters are totally incongruous and unrelated, we don't reach that point. And again, kind of rooting it in the jurisprudence of not just the single subject rule, but ballot measures generally. There is a underlying root, kind of an article of faith in these cases that any technical requirements for a ballot measure is to be liberally construed and all doubts resolved in favor of a ballot measure going to the ballot. That's, Ute, Air, Pullen, but I think virtually every ballot measure case this court has issued restates that premise. So again, you get back to...
None of that would trump the language of the Constitution.
I totally agree. But again, we're at the fundamental premise where, under the Ute Air case and under, I would argue, the clear language of the Constitution, it is impossible to decouple the people's power to make law and the legislature's power to make law, with certain listed exceptions that aren't relevant here. So again, every case that has discussed the single subject rule has restated that at least in the initiative concept, that the restrictions should be liberally construed, and that the single subject rule itself should be interpreted with considerable breadth, and only invalidated. A measure is only invalidated where the violation is substantial and plain. Again, I would go back to, 19 Acti. Even if you go back to, I think, some of the consternation I think individual justices have expressed at the single subject rule, there's a fundamental unfairness to punitively, retroactively applying it to a ballot measure that has been drafted, signatures gathered, and as of this morning is only 200 reviewed signatures out of the remaining 9,000 from being qualified for the ballot.
Who says it's punitive? Punitive or punitive retroactively invalidate? What would be punitive about it?
It would be punitive to take a measure that under the current, we would argue, under the current single subject rule, is a package and is an acceptable package under the single subject rule, and pull the parts away, leading to voter confusion, leading to, for example, if this court were not to rule until the ballot printing deadline, you'd have a ballot group saying, we want you to vote yes, but we don't know if we want you to vote yes on 1, yes on 1 and 2, yes on 1, 2, and 3. They are handicapped in their ability to communicate with voters.
That doesn't make punitive, though.
I was taking issue with the use of the word punitive. If we collectively decide that the Constitution requires that, that's not punitive. That's just a declaration of law under the Constitution.
Yeah, perhaps punitive is too strong a word, but it certainly, there's a harm to the sponsor's interests that I think is undeniable and can't necessarily be mitigated by this court should it decide to go in that direction. Again, I would believe, if you cannot decouple, and I will refer to the case law as sort of a unit, knowing that some are for legislative enactments, some are for ballot measures, but if you look at them as a whole, this court has previously approved much broader subjects. They've approved the subject of land, transportation, civil actions. Here, there's no question the ballot measure only substantively amends Title 15, which is one title under Alaska law, campaigns, elections, and how they're run, and makes 3, although important changes, 3 discrete changes that are interrelated and interreliant. A ranked choice election makes no sense in a world where there's only two party candidates, for example. The party primary, as discussed earlier, or the open primary, is much more confusing to voters without ensuring that they have transparent information about who's influencing their vote. Huff versus Parnell did not change the single subject rule. It really just showed the rule is alive and well. Again, to kind of review, it was public funding of elections was kind of the purpose of the Croft ballot measure. And then they added in, we're going to tax oil companies to pay for it, even though we can't dedicate the funds. And by the way, here's the kicker. If there's extra money left over, your PFD will be bigger. I mean, those are incongruous at the highest order. And in addition to being incongruous, being three separate buckets, in terms of log rolling, I don't know if there's any better political log rolling in Alaska than we're going to give you more money in your PFD check. So that case rightly decided under the existing rule. The rule works. Now, overturn this court's precedent in the two ways that the court needs, they have to overcome the weight of stare decisis. They have to prove that the single subject rule was originally erroneous, and that the plain language of the Constitution, or this court's interpretation in Ute Air of the plain language of the Constitution, that the people hold commensurate power with the legislature in terms of legislating, with certain exceptions. Whether or not the state thinks it's wise to give the people that power, I would offer that the court's interpretation in Ute Air of that language is absolutely correct. The Constitution means what it says, and it's mandatory and directory. I would argue that this court, based on the prior court's reading of Ute Air, cannot change what the Constitution says. It clearly seems to say the people shall have this power. It doesn't say, but we might handicap it in this way or that way, because imposing a very strict and now very subjective single subject rule on ballot measures, make no mistake, would not be procedural in nature. It would be potentially arbitrary. There would be no case law behind it apart from whatever course this court sets. But what they offer is decide if this is important, and then turn the dial up of how interrelated all the parts have to be. With ballot measures, the items are always of importance. You need to get tens of thousands of people to subscribe to your idea to even make the ballot. So of course they're important. And I would say, especially in this area, especially in an area like this, campaign finance reform in the past was acted on through ballot measure. For very good reason. Legislative ethics was acted on through ballot measure. This is acted on through ballot measure for the reason of, why would the people of Alaska expect that the people who got elected under the current system would fundamentally shift that system? If the people can't take this action on this subject, then what can they act on? And what real meaning does the ability to initiate law mean?
Your point is well taken, but the people can still enact these provisions by going through three separate initiative processes. They get to be heard if they want.
They could theoretically do that. They could also have a multiplicity of signature gathering requirements, a multiplicity of litigation, and ultimately a difficulty of electoral viability. For example, suppose, and I wouldn't dream of doing this, but if someone wanted to institute real criminal justice reform via ballot measure, and they said, I'm going to strengthen all these sentences, but on the other hand, I'm going to augment the rehabilitation services that are available. And this is the same subject, and it's coming at the problem from two directions, but that's the grand bargain.
And it's being made one.
It is, which is why I would say I wouldn't propose to do it by ballot measure. But that's when you have to attack a big issue, doing it with one arm behind your back and having to do it on marijuana, for example, through 6 ballot measures. What if retail sales were approved, but commercial production was not approved? What if a tax was approved, but retail sales of marijuana wasn't approved at all? The system would collapse within itself. And these pieces are similarly interdependent. A top 4 primary without ranked choice voting at the other end, you might get someone elected with 31% of the vote. Could be an extreme candidate, but they can coalesce around a certain base. This ballot measure is all about empowering voters and requiring public officials to answer to more voters and build larger consensuses. So taking out any one piece on the assumption that if you split them into three parts, they won't all necessarily get passed, could fundamentally handicap its ability to be effective, and then therefore fundamentally handicap the people's ability to pass law.
Well, that sounds like an argument in favor of dividing them into three. The people actually get an opportunity to vote discreetly on each individual proposal. And they might like two of them, but they don't like one of them.
And in the end, the sponsors of the initiative would be left with an elections reform package that they did not design, wasn't what they envisioned, and might just not work at all.
I thought this was all about the people's choice.
It is the people's choice, but the sponsors have the right to put the package forward. The people have the right to vote on that package. Any other group of Alaska voters can certainly grab one or two pieces, but again, not to be reductive in the discussion, but I won't guarantee it, but I would imagine that if a marijuana tax standing alone would garner one or more fewer votes than approval of retail marijuana sales. It's part of the grand bargain. There are people who design these things, and that's the risk they take, really, because the more complicated you build the machine, the easier it is to attack. So when these sponsors build a package and they say, this is a responsible and straightforward and smart approach to this issue, the rocks come flying in. It's too complicated. Vote no. What are they trying to do? A computer algorithm is going to decide who wins. That's the risk they take, but they're entitled to take that risk.
But your argument seems to set up some freestanding right for sponsors, and I'm not persuaded. I think the voters have a right to vote. If the sponsors don't do it right, that package doesn't get voted on. There's not some counterbalancing right to allow sponsors to say it the way they want to and demand that it be put before the board.
No, of course. The sponsors do have the right that within the four corners of the Constitution's restrictions, they can propose whatever they want to propose, and the lieutenant governor has to approve it, whether affirmatively or after court action. And again, goes back to the argument of, look at the Croft case. It sets the outer bounds of clearly what's not acceptable. Here, all reforms within Title 15, all reforms that impact one another. There's no question that dark money restrictions are going to give more information to voters at the primary and general election. There's no question that a ranked choice election will not work as well without the four candidates feeding into it. There's no question that the open primary with four candidates could potentially be a disaster without ranked choice at the other end, because it would have the opposite effect, where they're trying to get candidates that have a consensus. Now they've got someone who just got elected with 33%, and who knows what they're doing, because they answer only to one small part of their base, perhaps in their House district. Perhaps, that vote's decided by just the 2,500 people who voted for that individual candidate. And that's certainly not what the sponsors are approaching, and that would certainly undermine otherwise good, sound, holistic legislation. And again, if we get to, I think Justice Winfrey's very good question, it drives us back to the fundamental question. Can you decouple these two rights? Can you decouple the single subject rule for legislation and for ballot measures, and then go ahead and diminish the people's right to legislate by ballot measure? Because if you can't, then the question's answered. It's answered even by the state, where they said, well, that would be a disaster. Because what you'd end up with is, if the legislature had to obey this rule, you would end up with a governor that has line-item veto power over substantive legislation. Because you wouldn't have SB 91, you'd have 12 separate bills. And they could say, I like stiffer sentences, and I like this, and I like this. Oh, no rehab. Oh, none of this, none of this. And that can't be the answer. Alaska's got a five-decade tradition of a broad single subject rule. And again,
who was the major proponent of the broad reading of the single subject rule over the last 50 years?
I would argue this court has...
No, who was the proponent? Who sat in front of this court and argued that it should be a broadly countenanced rule?
I would say on occasion that's probably been the legislature, and on occasion it's
I've
been...
been saying almost every case it's been the Attorney General's office and the Department of Law, hasn't it? In every one of the cases, which we said, you look at the legislation, it's only going to violate the single subject unless it's clear and substantial. We've talked about the technical language. Every one of those cases, it was the Department of Law that was in front of us, urging us, in fact, in some cases, to go even farther. In the bonding cases, for example, they wanted us to say that bonding was a single subject and you could put 30,000 different bond proposals together in one bond, which we rejected and came up with a different version to say, well, as long as these bonds are somehow connected to water development at the time, certainly less than bonds there. But in every case, it's been the Department of Law that has said and urged this court to take the positions that we take.
Yeah, and Justice Winfrey, you make an excellent point, and I think that gets to kind of one of the fundamental root problems that we're dealing with here. Because we're dealing with, I think, make no mistake, a ballot measure that is disfavored by an individual administration. And to the point where it's not, we're going to indicate we're somewhat critical of this, or individuals are going to come out, but we're going to try to prevent it from going to the ballot, and we're going to come up with a brand new two-part 50 years of precedent overruling test in order to do so. And I would think a decision aimed at one particular ballot measure that is disfavored by the Department of Law would be a horrible reason to make such broad and sweeping new law. And again, I just want to, actually, before I move on, you made an excellent point there as well about the bond proposals. Because I think in response to questioning, Ms. Fox proposed yet a third rule. Whatever it is, oh, you're right, it's gone through the legislature, and now it's going to the people, and the people are voting on it, and it's got projects in Fairbanks and projects in western Alaska, but we certainly wouldn't hold it to this standard. So there must be some standard in between Croft and the one we proposed for pure ballot measures, which I think is an additional complicating factor. Now we've got a multiplicity of tests when the Constitution says there's one test, and the Constitution says the people have the lawmaking power that the legislature has, with those small exceptions. But I wanted to talk, I have a brief amount of time left. I did want to touch on this test that the state offers. Assuming you get to the point where you've decoupled it and you've created this new test, now a lieutenant governor gets to say, well, depending on how important I think this issue is, I can be hypercritical about this ballot measure that attacks this big issue. And it's an open invitation for subjective decisions to be made where in the past the case law has been pretty darn clear. Not only are we sweeping away 50 years of case law, at least as it applies to ballot measure, but now we're creating a test that's no test at all. Got to be interrelated, and the more important it is, the more interrelated it has to be. I'm not aware of any basis in the Alaska Constitution, she can make many fine policy arguments, but I am unaware of anything in the Alaska Constitution, statutes, or case law that bear any support for this new test. I would also argue that if this court is considering going somewhere different with ballot measures, considering the stage we are at, prospective application, just as was proposed by prior dissenting justices, is what's fair. If we are going to announce that the prior 50 years, at least as it comes to ballot measures, don't count anymore, are we going to, at a point where 41,000 signatures of Alaskans, 41,000 Alaskans, not just as sponsors, right, but those Alaskans as well, are going to be told, no, we're taking another look at this. I would say that's an unjust, not punitive outcome, certainly, but certainly an outcome that harms interests, and harms interests of tens of thousands of Alaskans, and harms perhaps all Alaskans when they would have the right to vote on this issue.
We're not bound by the state's proposed resolution of this, though. We could apply Croft now, use its means and magnitude test, along with its restated Gellert test, requiring all matters treated be connected or related with each other, as to be parts of or germane to one single subject. And it's plausible that we could find these three items don't meet that test. We just distinguish this case from the others and say this is more like Croft than the others, and there you have it.
And I would respond to that by saying Judge Lamoure's decision was extremely well reasoned. She looked at the Croft case, she looked at the entire DNA of the single subject rule, and said
our decision would be very well reasoned too.
Absolutely. And she looked at that DNA and she said issues of land, issues of civil actions. Here we've got elections reform, and elections are, for all intents and purposes, they're one system. They are a system that involves a primary, nominations of candidates feeding into a primary election, feeding into a general election. There's some petition candidates, there's some bells and whistles, and then campaign finance lays like a gloss over all of that. And so I guess I come back to the fundamental disagreement that these issues are not all clearly interconnected. And I wanted to sort of sum up real quickly, if I could. Again, back to the underlying law of ballot measures, to uphold the ballot measure wherever possible, to not find a violation of the single subject rule, but where that violation is substantial and plain. This court the state not only asks for the overturning of the decoupling of the single subject rule and a new single subject rule, they ask you to explicitly say that the court in Ute error, when it interpreted the plain language of the Constitution, got it wrong, which is kind of another layer and another gloss, I believe, on the precedent in this case. The people of Alaska have a robust power to legislate via ballot measure. That was envisioned by the Alaska Constitution. Whether the state disagrees with it in this instance or not, if the legislature could do this, and I believe they could, then the people can do this. All Alaskans have a right to vote on whether to enact this ballot measure and improve this election system. And it's critical that the people have this power, particularly on this subject, because again, this is never something that legislators would be expected to address. Accordingly, we respectfully request that the Superior Court's decision be affirmed.
Ms. Fox?
Thank you. Now, I first want to respond briefly to Justice Winfrey's point about the Attorney General's office position in prior cases. Now, the Attorney General's office is obligated to, for the most part, defend laws that are on the books. And in most of these other cases, as I mentioned before, we're talking about laws that were on the books. So we're talking about, for instance, someone who's accused of engaging in some kind of land fraud, saying, actually, none of those statutes that you're prosecuting me under should apply because, 5 years ago, 10 years ago, whenever they were enacted, they were part of a bill that was too broad. And so in cases with that kind of posture, it's different. It makes a difference when we're talking about, something that's still pre-enactment versus something that's been on the books. And I think that language about, we're only going to overturn enactments when they're substantial and plain applies to enactments. And when we're here and when we're in this pre-election posture where, the Lieutenant Governor is given this obligation to review the ballot measure before it goes on the ballot and, apply the Constitution to it, it's a different kind of situation. And that sort of extra substantial and plain violation gloss on the single subject rule doesn't apply, and we want a meaningful single subject rule, and the court can consider these other things. So it's a different posture. The sponsors are sort of, to some extent, saying, drawing these lines is hard. So they essentially want what's essentially no line, or not a line that actually furthers those purposes discussed in Croft. If you look at the purposes discussed in Croft, saying all we need is a broad subject like elections or land doesn't actually further those purposes. It doesn't protect voters from sort of confusing multi-subject initiatives, from the possibility of log rolling, doesn't allow them to meaningfully express their will. If we have, if it's not 100% clear exactly where this line would fall in every single hypothetical initiative we come up with, that doesn't mean that the sponsors are going to have to litigate this in every case. There's little benefit of forcing voters into an all-or-nothing choice on unrelated proposals. Proposals actually are inextricably interrelated, then they will be related under the standard. And what the sponsors are saying is, well, we want all of these things to go together because we're afraid the voters won't vote yes on all of them. They're basically saying they want log rolling. They want to be forcing voters into an unnecessary choice.
Why isn't that a choice that the sponsors can make, though? I mean, if they have a multi-part bill or multi-part proposal, and they think it's only going to work if all 4 parts are enacted simultaneously, I mean, they're basically acting as legislators, as the Constitution says they can. Why isn't that just part of their prerogative to frame it in that way as a 3-legged stool or a 4-legged stool?
Well, they can make their case to the voters, but it's the voters who are the lawmakers, not the sponsors. And you know, the point of the single subject rule and the point of our argument here is actually about protecting the initiative process. So the voters, again, it's voters, not the sponsors, that are the lawmakers. And so we want, you know, the voters to have a robust power of initiative. And so, you know, these points about, you know, technical violations and liberal construction, it's true, you know, want to protect that process, but it's the voters, not the sponsors, that the court should be having in mind and trying to protect the initiative power.
Well, doesn't the initiative power depend, though, on both parts of that spectrum? I mean, if we're not protecting those citizens who are creating the initiative and putting it on the ballot, collecting the signatures and everything, and they never have the opportunity to bring that to the voters, how is that protecting the voters?
Well, they can bring again, you know, under the rules that we're proposing, we're not saying that these things can't go on the ballot, just that different proposals have to go on the ballot separately. Voters have to be presented with, you know, distinct policy choices, not sort of packages of unconnected policy choices. Sort of, you know, the court can refer to, just as an example, the Massachusetts court's language about proposals that just present voters with a coherent question. You know, do you, you know, want to have ranked choice voting? And then there's going to be implementation details in any initiative. There's going to be ways that could or couldn't be different, and the sponsors get to pick, you know, how exactly that ranked choice voting is going to work. But in the end, the sponsors need to be, or the voters need to be presented with a question that's more along the lines of, should we have ranked choice voting? Then, do you want to change things about elections? Just some things, like a collection of things that we think are good ideas.
Who does the single subject rule protect when it's applied as legislation?
I mean, I think
individual legislators, because they're the voters, or does it protect the public?
It protects I think the public protects the process. It's make sure that, you know, I mean, that there's already this mandated public process that the legislature is going through, and some of the safeguards that are built into that process and the things that are built into that process already, you know, take care of some of those concerns, which makes these purposes sort of less, you know, less heightened concerns than they are in the initiative context. But yeah, I mean, it's about protecting the, you know, the lawmaking process, making sure that you know, everything's out there in the open. You know, people know what they're voting on. I mean, the legislators aren't ever in the position of voters who might go into the ballot box and be presented with this initiative that they've never seen before. And the legislators are never going to be in that position because they already, you know, they have to go, you know, they have to go to the sessions, they have to have these hearings. And so there's differences between the processes. But yeah, it's to protect the process. I mean, it's not to protect the sponsors, or, you know, it's not to protect the legislator who proposes the legislation. It's to protect the process. I mean, and you know, I just want to briefly talk about, you know, remedies. So here, I mean, the most sort of normal way to deal with this would be to uphold the Lieutenant Governor's decision not to certify the initiative. It's not, still, again, not to say that the sponsors can't pursue these initiatives. They could start over again. So, I mean, and both parties are, you know, have expressed some discomfort with the idea of the court editing this. But again, you know, the state said, you know, if the court, you know, sees it as necessary, you know, the court could do something else. But, you know, could split up the initiatives, although that would be somewhat unusual.
How would we do that?
I mean, that's part of why it's an unusual remedy, because I mean, really, it's a, you know, it's a strange thing for the court to be doing that itself, as opposed to the sponsors sort of deciding how they want to start over with the pieces of their initiative. But
They don't want to start over.
voters,
I would guess that if they don't get what they want, have us just affirm the Superior Court, they would much some order that would allow them to go forward in 3 pieces without having to start all over again.
I mean, they could have split this initiative up earlier. I mean, again, like the benefit of lumping these things together and the need to do that. I mean, the problem could have been corrected earlier in the process. But in any event, it's in the court's hands. I did want to mention one thing, which is that we would, I think, need a decision by, at the earliest, June 29th, which is the day before the candidate.
Earliest, or
Yeah.
that's the latest?
That's well, I mean, there's some contingencies as far as, like, when they get their if they get their signatures, when they get them, when they turn them in, et cetera. Like, the deadline could be later, so that's the earliest one that it would be. I mean, and if the court would like, the state can submit an affidavit laying out all of the deadlines of things for the court's consideration in deciding the case, to make that clearer. But the state requests that the court...
The parties could jointly submit something. I think that would be helpful.
Right. I think that the relevant information would mostly come from the director of the Division of Elections. So, but yes, the parties could jointly submit something on that. That the state requests that the court affirm the Lieutenant Governor's refusal to certify this initiative. Thank you.
Thank you, counsel. And thank you to both parties for your excellent briefing and argument on interesting questions. We'll take this matter under advisement, and we're in adjournment.
State government on Gavel, Alaska is made possible by viewers like you and these sponsors. The community.
Thank you all for tuning in today. I hope you enjoyed the show. Don't forget to share. This is Ballot Measure for Better Elections. The state Supreme Court today was hearing the case being brought to you from Kevin Myer versus Better Elections. This has 3 different things that are happening in there and one of the most that we should all be concerned about as Alaskans would be ranked choice voting. I posted several examples in the comment today of what ranked choice voting is and how it works. I will produce another one that will be put out as an individual post later on today that breaks it down step by step so you get a real clear understanding of what is happening here. This is what they used in Iowa. Anybody that watches the news has seen what happened in Iowa. It is still a disaster area. As far as I know, they still don't know who actually won. If you were to go under the 240 years practice of voting that we have in the United States, Bernie Sanders would have been the clear winner. He had what they call the popular vote, which is the first round voting, which showed him percentage-wise as the winner. But under ranked choice voting, until someone gets over 51%, nobody is a winner. Don't forget to share. Thanks for paying attention and tuning in today. Have a great one.